All right, welcome to another edition of Lawcats Live. I'm Keith Swisher, and I have the pleasure of being today's host to talk about the legal paraprofessional, inspired by the medical field's nurse practitioners who have proliferated across the country in a few short decades. Legal paraprofessionals, or LPs for short, are one measure to address the significant gap in access to justice. The state of Arizona has gone farther and faster than any other state in this regard, including other innovative states of late, like Utah. And with the advent of LPs, the hope is that fewer folks will have to go without an advocate when they need or are faced with important legal proceedings. We gather today to learn about what an LP is, to celebrate the remarkable progress in a short time frame, to hear how you might work with or across from LPs in the near future, and to answer your questions. And many of you have already submitted very thoughtful questions, and we hope for more today as well. But first, I have some words of welcome, thanks, and introductions. First and foremost, thank you to all of you for joining us today. Lawcats Live has been such a fun and timely way to reach our impressive community of alums and friends. And thank you all for carrying on that tradition. This event could not have happened without the significant contributions of many folks, both inside and outside the College of Law. At U of A, first, let me say, Christy Claremont, who runs all things LP at the College of Law, Kate and Megan in the Alumni and Development Office for creating this forum that brings us together here today. Dean Mark Miller is one of the key legal innovators in the country, as you all know. And for UA in particular, none of the educational process would have been possible without his energy and support and intellectual contributions. UA also boasts Stacy Butler, who's also a noted innovator, served on the task force for the delivery of legal services. We also have this marvelous team helping to generate ideas and to implement LP education, including Linus Kafka, Leah Wan, Lauren Easter, Catherine Monroe, Jesus Carranza, and Mark Blair, a communications team led by Ali Bridges, helping to get the word out, and many, many others. There's not time, unfortunately, to list everyone, but it's really just a marvelous team. Also, I want to give thanks to the courts and the particular reps who are with us today. We have, for example, Pima County Superior Court represented. We have Phoenix Municipal Court, Marana Municipal Court. We have representatives from New Mexico, maybe even including, I don't see the full participant list yet, but Jennifer Albright, who is one of the early architects of our particular program after following the lead of the task force. And we have educational institutions, wonderful ones represented, including Pima Community College, our dear neighbors, along with Phoenix College and Rio Salado. Everyone there has been extremely collaborative. We look forward to the road ahead together as fellow educators. And now let me welcome our esteemed panelists. I'm only going to introduce them briefly so that we could get to content and questions, but let me at least introduce them briefly. Probably needs no introduction, but we have Vice Chief Justice Timmer here. Justice Timmer is a devil, both a sun devil and a blue devil, that is, but perhaps most notably, she's also a wildcat. Before joining the Supreme Court, she was the chief judge of the Arizona Court of Appeals Division I. Everyone agrees that Justice Timmer, who headed the task force, was simply instrumental in creating the new practitioner about whom we'll be talking today. Next, we have Judge Cruz, who served on the Yuma County Superior Court before being appointed to the Arizona Court of Appeals. As a double wildcat, she's perhaps the most distinguished panelist. And like Justice Timmer, one of the key guiding forces in this new and exciting pathway about which we're about to dive into. And let me certainly mention our other panelist, Aaron Nash, who directs the certification and licensing division at the Supreme Court of Arizona, and previously headed up communications and outreach. As with Justice Timmer and Judge Cruz, he's dedicated access to justice. The only catch is he's not a wildcat. But that's true of at least a few other good folks who are on the Zoom today as well. So with that.
But I married a wildcat.
Oh, okay. So I knew that you got through our screening process somehow. No, I'm just kidding. Thank you so much for your time. We can't wait to talk about this. This is really, this development has so many possible impacts, but also raises questions and concerns that we want to address and hear about it all. So With that, let me turn it over, I think fittingly, to Justice Timmer to get us started. Thank you, Justice.
Hey, thank you, Keith. And hello to everybody. Good afternoon, I guess, at this point. I am going to be very brief because I'm going to set the stage for you regarding the legal paraprofessional program. And so take you back in time a little bit to explain quickly why we did it and what we've done. And then the details will be filled in with everyone else. And of course, if you all have questions at the end, we're delighted to answer them. So what are legal paraprofessionals? First of all, they are just what you see. They're a new tier of legal service provider who are recommended by the Task Force on the Delivery of Legal Services that I chaired. That is, as Keith said, Judge Cruz was a member of that. Jennifer Albright staffed that at the time, working at the Supreme Court. And really what that was born out of was the desire to examine the regulation, the practice of law in Arizona to see what can be done to close the access to civil justice gap, which everyone knows exists in our courts statewide, nationwide, really. And it's only ever growing and has been since the 1970s. So we looked at a number of things. And what we're focusing on here today is, well, can we do something like the medical profession has done very successfully with having nurse practitioners, physician's assistants, phlebotomists, all kinds of different people who have their own special talents devoted to particular areas. So that's what we looked at. So we decided on, yes, we can have this new tier provider. We will license them. They have to have a specific education or training that we'll get into, pass an examination that the court administers after consultation with the psychometric people that put these tests together. And they're licensed by the Arizona Supreme Court and endorsed for limited areas of practice. And they become then affiliate members of the state bar with the same obligations that lawyers do in terms of paying dues every year, satisfying continuing legal education, subject to the same discipline system that the lawyers are, and have the same, essentially the same ethics code that lawyers do. So, well, we're going all over. Next, there we go. There's our rule. For those of you that want to look the rule up, it's under our Rule 31.3, which defines the practice of law. And then there you have it. We have legal document preparers and legal paraprofessionals. Document preparers are folks who are not, they're licensed by the court to help people with filling out forms. They are not supposed to give legal advice. They're not licensed to do that. So simply filling out forms, that type of thing. We have about, Aaron can tell us, 600 to 700 of those folks doing that. Some of the times it gets blurry about what's advice, what's not advice, and that's an ongoing issue. But going up the chain, you certainly have legal paraprofessionals who can give legal advice, just like lawyers can do, but only in limited areas. So this is the Code of Judicial Administration, which most people don't even know exists, lawyers out there. If you have your rule book, your desk copy, I should have it here. I will show you in this big, thick book, which gets thicker every year that we make rules up. The very back is the Code of Judicial Administration. That's what gives you all of the detailed information of what's required to be a legal paraprofessional. The education, the training, the ethics, the discipline, everything is laid out in there. So if you're interested in doing that, that's where you should go. All right. I told things that they're entitled to do. They really, just like what lawyers could do if they're licensed, prepare and sign documents, provide advice, draft and file documents, appear in court or at other tribunal, and negotiate legal rights. Here's the thing to stop and pause and focus on. What are the limited areas? When you graduate from law school and you become licensed in this state, there's no limitation on what you can practice in, except maybe patent bars. Patent type thing requires an extra bar, but everything else, you can go into any court and practice law in Arizona, as in most states. So a legal paraprofessional cannot do that. They are taking tests and being licensed to these specific areas. Here are the 4 general areas in which a legal paraprofessional can practice. Focus for a moment on the 3 categories to the right of the slide: civil law, criminal law, admin law. These are three areas that you don't see a lot of lawyers practicing in. The civil law matters are before municipal or justice courts. So the matter in controversy is going to be less than $12,000, $12,000 or less. Landlord tenant, small debt, that kind of thing. You don't see a lot of lawyers doing that because it's simply not economically feasible for them. In the criminal law, initial appearance and to negotiate pretrial release, so the bail hearings, that type of thing, but also criminal misdemeanor matters, but as long as jail time is not at issue. So if jail time's at issue, you're still either pro se or you get a lawyer. But if jail time's not at issue and you're talking fines, that kind of thing, you can get a legal paraprofessional. And then the administrative law arena, you can practice there if the administrative agency permits it. So those are the three general categories where you don't see a lot of lawyers. Now, family law, you do see a lot of lawyers, but frankly, you don't see enough lawyers. For example, when we were doing our task force, we got figures from Maricopa County, which for those of you that are out of state, that's the largest county in Arizona where Phoenix is located. And more than 95% of cases had at least one unrepresented party. And in more than about 75% of the cases, both were unrepresented. So you can see there's a real need for people to get help in family law. And there just hadn't been getting it through the lawyers, either insufficient number of lawyers or more likely the cost of lawyers, which is not a ding on lawyers. Lawyers need to charge sufficient rates, obviously, to make a good living, to pay the overhead, to repay student debt. Frankly, it's not a cheap endeavor, though, and I think we can all acknowledge that. So as a result, our courts have really clogged up with people that are in search of how to get through this system in their family law matters. We can only do so much with making the rules as simple as possible, with having self-help centers in most of the larger courts, at least. And still, it's a confusing, upsetting time for many people and a very difficult system to navigate with them just through the emotion of it. So we've decided to allow legal paraprofessionals to practice in this area as long as they pass all the requisite background and substantive testing, except in a few areas that can't do quadros or division of business retirement assets. It's a little more complex without further requirements from the court. They've satisfied that. And they also can't engage in appeals. So the idea is it's a more straightforward type cases that they would be engaged in. So that's where we are with the four areas. I can tell you, at least anecdotally, in speaking with judges who have already had trials done by legal paraprofessionals, and we haven't had a great number yet, but so far in talking to those judges, at least there's been two, I think, has reported saying they did great. Everything was just as expected that they would expect of a lawyer, and they're held to the same standard, frankly, as a lawyer in court as well. So that's it for me. I pass that on.
Justice Summer, if I can chime in, you mentioned that the number of persons, self-represented litigants in family cases was large, and I'm sure it has grown since the task force was studying these issues. I recall that not only did we talk about how can the centers reforms for self-represented litigants, how those assist, but they're not enough. You just mentioned that. But also I remember that the number of pro bono hours that would be required to meet the need was just astronomical. If every lawyer in Arizona took on, if we sliced it up so that everyone who needed legal representation was able to have it, it would require, do you remember how many hours per attorney?
I do. It wasn't just unique. The one I remember from it was for the entire country. It would be 900 hours per lawyer to meet do pro bono, which is not really fair to expect that is going to happen.
Right. That's my recollection. And so really, it's a situation where the demand is far greater than can be met by current lawyers. I also just want to mention that I did in Yuma County, I sat on the family bench for a number of years. And I found that it was more difficult than having two self-represented litigants was having one self-represented litigant, another person represented by an attorney. The court can only direct the self-represented litigant so much before they turn advocate for that person. So you have to be very careful in that regard. So from my conversations with judges across the state, they are relieved that now in the horizon, at least, there's the possibility of offering assistance to so many people. And I think that's where we're going to see the most growth in terms of legal paraprofessionals entering the delivery of legal services in Arizona.
Yeah. And I will, since Judge Cruz brought it up, it reminded me too that the idea isn't just these legal paraprofessionals can practice on their own. I don't know that any are at the moment, but I've heard from a number of family law practitioners who said, hey, at first they were a little concerned about this taking business away from them until they realized that they could use their paralegals to then could be licensed, and they can deploy them in the cases that they otherwise wouldn't take on because it wasn't economically feasible for them to do, but they were comfortable and confident that their LP could do it. So it's actually helped them expand their business, which is also the benefit of the lawyers and, of course, the public.
And now that you mentioned that, Justice Timmer, similarly with criminal law, we have on the slide the initial appearances and pretrial release, negotiated pretrial release. That's the bail hearing. And we're talking about the very first hearing. We're not talking about the conditions of release hearing that is set down the road. We're talking the first 24 hours. Most people do not have representation. Now, as a criminal defense attorney, imagine if you can have a legal paraprofessional go down and be available to walk people through. I mean, even to get family members to where they need to be, that's a very confusing time, especially for people who've never been arrested before. And to have someone who knows what are the issues that the court is going to focus on legally. People typically are talking about guilt and innocence. He didn't do it, he did it. And the judge is trying to focus people. What I'm trying to determine is safety of the community, this person's likelihood to come back. This is not the moment for trial. So having an advocate there who can help negotiate that landscape is going to be invaluable. And if that legal paraprofessional is associated with a criminal practice, then the attorney can decide if they're going to negotiate an agreement where there's going to be further representation by the attorney in the criminal case itself. So there are a lot of opportunities for lawyers.
Okay, Keith, I think that's you.
Thanks so much. So let me carry on the momentum here of explaining what more about what the legal paraprofessional program is and how you might become and remain an LP. And there you have education and ethics. So there's two routes to essentially become, or at least to be qualified to become an LP. One is educational, one's experiential. The educational routes you see there at the top bullet, you'll notice a lot more is listed than just the JD, which of course has become sort of the common route in the US for lawyers. But you could also qualify through Master of Legal Studies degree or an LLM or a BA in law, or even an AA with certain paralegal certifications and a year of experience. You could also qualify just through experience if you've had 7 of the last 10 years in significant law-related experience. So you can see these are broader pathways for someone to become a legal advocate than what were available for those who wanted to become lawyers before this program came around. The next slide, there are a number of different educational institutions, including, of course, the U of A. We have our Master of Legal Studies program. And we have students studying to become legal paraprofessionals already, and we have some students who hope to do so soon. We also have our Bachelor of Arts in Law program, which is approved for that pathway as well. The Bachelor of Arts in Law is a partnership with our School of Government and Public Policy and the College of Law, and it delivers, we think, a really unique rigorous education in law for undergraduates, and we think it's a perfect platform for someone to become a legal paraprofessional if that's their choice. Also, ASU's modifying platform, Pima and Yavapai have made good strides. And then I know some of the other community colleges like Phoenix and Rio Salado are very much steeped in this development. So the educational institutions are gearing up and welcoming future LPs in their curriculum. And once you become an LP, many wondered, especially during the development of this program, okay, well, what regulation would this new category of practitioner have, if any? Are we going to be, subjecting the public to harm? And one of the sort of ethical overview here is that their ethics and regulation is identical to that of lawyers. I mean, very few exceptions. So they can be disciplined by the state bar, suspended, disbarred for the same offenses that a lawyer could. They have to take the mandatory professionalism course. They're bound by the creed of professionalism. It even says the creed for both lawyers and legal paraprofessionals. If you're going to be taking money in advance on behalf of private clients, you have to have a trust account, just as a lawyer would. Likewise, in Arizona, just like lawyers, you have to disclose whether you have malpractice insurance. So the overlay is identical. There's not fewer ethics, so to speak, or less regulation for legal paraprofessionals. It actually goes a little bit more than that, because the next slide teases.
Before you move on from that, Keith,
yes.
One question that has come up since we began with this concept was whether or not legal paraprofessionals would be required to carry malpractice insurance. Can you talk about that?
Yes, I could. Thanks for the question. You probably know my view on this. So Arizona is one of the states that laudably requires malpractice insurance for attorneys. Many of you listening, I know that you disclose yearly whether or not you maintain malpractice insurance. And for those of you in private practice, I believe all or the vast majority of you do. Thanks. Of course, do I think we should be one of the exceptionally few, believe it or not, states that require malpractice insurance? Absolutely. I know that comes with a lot of headaches, like who the insurer would be, et cetera. So it's not that far, but it's not that far for lawyers either. That's not like a suitable response. Just because we don't do both. I think we should do it for both, but right now it's equal, and at least it's a disclosure requirement. And again, I'll say that it's not like I could point to a lot of states that require malpractice.
Yeah. So tell us how you really feel.
Yeah, right.
But this is actually a point that we debated quite a bit in the task force, and some of the members felt that legal paraprofessionals should be required to carry malpractice insurance. But at the end of the day, I think we landed on the side of not requiring it because we didn't want to make the certification for legal paraprofessionals more onerous than the requirements to become a lawyer. I mean, we saw that in Washington State. Their program has sunsetted, and I think there's some effort to revive it now. But sometimes the requirements for a certification program just become so much that then you don't have the effect of having a sufficient number of people interested and become certified. And I think one of the beauties of the Arizona program is that the requirements that we have are less than those to become a lawyer, but they're targeted so that the people who are certified are going to be prepared to do a great job for the people they represent. As you're covering not only the ethics, but the law courses that they're required to take and the experience that they're required to have is sufficient to ensure that they know what they're doing. In fact, probably it's more specific training than you get when you have a law degree and you're just entering the workforce.
Yeah, very well said. Thank you. I definitely agree. I thought the task force and the court was wise to look at Washington's experiment and how it was so constrained that, to my knowledge, it never really flourished, and then of course was sunsetted. So I thought that was really wise. Let me just end on the insurance disclosure. you have to disclose, and it's also advisable to get insurance if you're going to be an LP in private practice. And Ahern, my understanding, the bar's broker, can help find you that insurance. So it's great that it's available and it's advisable out there. And then a little bit more on your screen about LP ethics. So perhaps the most obvious one is that LPs have to stay within their scope of practice. Many of you probably visited nurse practitioner. My experience with nurse practitioners has been very efficient and wonderful overall, but they didn't try to go outside their scope and say, offer an operation for which they weren't authorized or something like that. Somewhat similar. LPs have to make sure they stay within the authorized scope. Those 4 boxes that Justice Timmer showed you earlier, anything beyond that would be unauthorized. Also, that second bullet point you have on your screen is important. They can't refer to themselves as lawyer or counselor. That would be misleading to the public. It might imply that they could practice outside of those 4 tiles. Also, for those of you who are judges on the Zoom or litigators, for example, or court services, they have to identify themselves fairly regularly. Pretty much any document they submit to the court, initially to the client, that they're LPs, and they have a bar number. And so, in short, they have to disclose who they are to avoid sort of confusion. I know just being a new program, there's naturally going to be a little bit of confusion, but it shouldn't be caused by the LP. They'll have to disclose that they're legal paraprofessionals. Next slide, please. So because we all wanted to see your faces and we wanted to have more interactive, but webinar and Zoom doesn't really permit that. So we decided to add in these little quizzes. They're true, little knowledge checks. They're true, false. I never use true, false, basically on a test because maybe it's as a lover of philosophy, I think to say something is true or false, it's very hard. You have to make so many qualifications or define truth or falsity to like this level of absurdity. But anyway, just answer and have fun. Your answers are anonymous. So first one is, an LP needs only an associate's degree to practice law. What do you think? Again, totally anonymous. No one's holding you to this. Just have fun with it.
As I understand it, we won't know how folks answered, but we'll know whether they answered or not. Is that right?
We're not even going to check that. We'll know in the sense of like the response. So far, 34 folks, now 35 have responded. But don't worry, there's nothing that the Supreme Court or anyone else will be looking into if you don't answer this question. Okay, so we'll call this one. It looks like the vast majority, about 76% thought it was false. And I would say that's probably about right. I mean, the true part is, back to Judge Cruz's good point about we wanted this to be like an efficient pathway to practice law, assuming the person is qualified and ethical and whatnot. You can actually become an LP with an AA, but it also needs to have either focus on paralegal studies or an additional certification plus 1 year of experience, which sort of tips it into the false answer. So credit to both answers, of course, but probably more closely false in and of itself. But it does highlight how this is, a more expansive sort of educational array of opportunities for someone to become an LP. So let's do the next question. We've got an LP will likely earn more money than an attorney. True or false?
I want you to know the Jeopardy song is playing in the back of my mind.
We should have cued that in. That's a good point. I'll share these. I think we could share these results. This was unanimous. It's all false. And in some ways, that's good, right? Because the idea was that for like the folks who would have gone without a lawyer, that they can get a trained legal advocate through these educational and experiential pathways that we mentioned for less money than they would for a lawyer. So, and you all agreed with that. Now, I'm kind of surprised that everyone agreed, because I know we've talked with a few people who are like, well, what guarantees that? They could charge $1,000 an hour. Justice Timmer, you've had some good responses to that in the past. Would you like to comment on that question that's on people's minds?
I get asked that a lot. How can we control it? And unfortunately, antitrust laws won't let us set the hourly rate. I would love to control it and set an hourly rate, but they won't let me. So we rely on the market to set that rate. We've worked with the Bar Association through their Find a Lawyer. I don't know if any of you go to that page, and you can, if you're interested in finding like a family law attorney, for example, or help, what they have there is they outline, okay, here's the people that we have practicing in family law, all the way down from the Cadillac of practitioners who maybe do very complex things and have been practicing for 20, 30 years, down to the legal paraprofessional. And so you can see their experience level, and then what they charge for it. Well, if you're a legal paraprofessional, you're surely not going to be charging more than the much more experienced attorneys, or frankly, probably any of the attorneys, because why wouldn't the person just go to an attorney? So we feel like the market will kind of settle itself there. But time will tell. That's one thing we can't control. In part from our experience in talking, I know there's I think some Washington folks online here. But feedback we got back from Washington was that some of the regulations and the training and everything were very onerous and expensive for those that applied to do this. So they needed to recoup a lot of what they had invested in it. So we have really endeavored to hit the sweet spot of not overly regulating these folks, but to the point where the public is sufficiently protected. And our hopes that folks will be able to still earn a good living without having to be tempted to charge more than their services should be charged in the market that we have.
Great. Yeah, thank you. And the scope is obviously more limited, which has some implications there as well. So next question, and true or false, an LP may contact a represented party without the consent of that party's lawyer. Hey, we're getting great poll participation. I just want to compliment as we're going along.
All the lawyers should get this one right, I would hope.
It's great. All right, so we'll close this one and we'll share results. Okay, 86% thought this one was false, and that is correct. Could someone do it lawlessly? Sure, but if they did, they'd be violating ethical rule 4.2, which applies word for word to legal paraprofessionals. They instead would need to get the consent of that party's lawyer or not do it. For those of you who said true, I would love to unpack what you were thinking with that. I mean, because you might have come up with some plausible scenarios, but generally speaking, it's false and by design. False.
I'm thinking, Keith, it's probably a thought that because they are not lawyers, actually, that then they are on par with the party and they could have contact with the party, which is not correct, absolutely not correct, because these legal paraprofessionals, as we've been mentioning, are subject to the same ethical rules as lawyers. And so for these purposes, they are treated as lawyers.
Yeah, very, very true. Thank you. We got one more, and then we'll turn it over to Mr. Nash. So true or false? I must treat LPs civilly and courteously in and out of the courtroom. Interestingly, for some reason, I cannot see the results of this one. So maybe one of the esteemed panelists could let me know how this one turned out. I'm hoping it's.
We can't see the results. Okay. I mean, I can't, but I am willing to bet everybody said true.
Oh, here we go. Yes. Well, 92% did, as it turns out. Okay,
and we have 3 people who are just trying to have fun with us.
Yeah, maybe. Okay, yeah. So of course, you must treat LPs civilly and courteously. If you look in the creed of professionalism, binds all lawyers. If I don't even know if it was a lawyer who was answering or not, but just the point is we're absolutely bound. And in Arizona is one of the handful of states where professionalism is actually mandatory, subject to discipline if it's not followed. So that one's true. I mean, there are a lot of other reasons in virtue to treat LPs civilly and courteously, but it's actually mandatory in Arizona. So thanks everyone for responding. Next, we'll turn it over to Aaron Nash, who's going to talk a little bit more about the application process and where things stand in terms of LPs licensed in Arizona. Thanks very much, Aaron.
Okay, thank you. So the process of getting licensed to be a legal paraprofessional, there are examination requirements in the Code of Judicial Administration. So everybody has to take and pass a core exam, and then there's a subject matter exam. So whichever endorsement area you're going after has its own exam. It's a 3-hour multiple choice exam. So you can take one, come back for the other, or we have days scheduled where you can take one in the morning, come back in the afternoon for your endorsement area. And so that's for each of the endorsements, and you can have multiples. I might have a slide on this, but there's only 1 or 2 people, I think, who have family and civil or civil and criminal, but those are options. You could come back and get the endorsement in each of those subject matter areas. The application process. So the way the code is designed, you first take the exam to qualify, and then you file your application, which then gets reviewed by the division here. Then a recommendation is made to the Board of Non-Lawyer Legal Service Providers. And for those folks they approve for licensure, they become affiliate members of the state bar, as I think the vice chief mentioned early on. As of right now, 41 candidates have passed the core exam and at least one of those subject matter exams. And back to what you heard earlier, most of those are in family law, 34 in family law, 4 civil, 3 criminal. That's kind of what the task force and others thought. That's where the greatest need was in terms of self-represented folks in court. And that's been the result so far. And I think those numbers will increase as the BA and law program, some of the other schools get up to speed and are training folks in the different subject matter areas. So 22 licensees have been approved so far and are out there eligible to practice as legal paraprofessionals. And again, the breakdown for that, 20 of those are family law, 2 in civil and 1 in criminal. And then this is the one LP has an endorsement in both family and civil. And then those areas of practice. So like you can look up an attorney on the state bar's membership directory. You can see the legal paraprofessionals as well. When you do a name search, I think there's a tab across the top that you can toggle between attorneys and legal paraprofessionals to verify that they've been licensed. So what's next here in the division? So operationalize the program within the division here. Part of that is the outreach, like we're doing today. So you have me today, but Suzanne Porter is our Legal Service Innovations Officer. I'm comfortable saying the person who's most knowledgeable, knows the codes in and out, the court rules, the programs, those kind of things. So we want to expand, do more of this outreach, work with the schools, those kind of things. In fact, we just posted a job opening today for somebody to work with Suzanne to kind of go through those applications and help that so that Suzanne can work more on those code changes, rule changes, outreach. As these programs ramp up, we need more and more people to keep that running. And that will come with more data collection and analysis as well. Keith mentioned the program in Utah where they had a staff of analysts who could do data research and compiling information. We just don't have that. We have a staff of 2 right now. So that's one of the things we'd like to improve on as we move forward. And again, judicial education, working with the state bar, working with the schools, businesses to talk about what these opportunities are, what these legal paraprofessionals can do. Most recently, that's the administrative law practice that the vice chief mentioned. The exam for that is near completion, but not ready yet. And right now we're in that outreach stage. So talking to the administrative state agencies to say, here's what a legal paraprofessional is. Once they start getting endorsed to practice in administrative law, here's what they can do in your agencies if you allow it. So those discussions are going on now. And then as we go, we learn and get input from the public, from the LPs, from the lawyers, which then translates into making proposals to this regulatory board. Hey, we're looking at this kind of change. We're looking at these clarifications by rule and code. So that's more of the work that's going through the division now.
So just to recap, here are the things, if you remember nothing else about the statistics we've talked about and about all of the reasons why we came to the legal paraprofessional certification program, do remember that the legal paraprofessionals are affiliate members of the state bar. They're going to be in courtrooms. They are in courtrooms already. I think the question earlier about whether they need to be treated with respect, it's obvious that they do, as anyone should be in the courtroom or out of the courtroom. But I think it's to get us in the mindset that these are professionals who are going to be working alongside lawyers and to afford them that courtesy as people who are able and have been tested to do the work that they're doing in the courtrooms. They are not required to practice law under the supervision of an attorney. Many will, I think all currently, all LPs are working in law firms that were previously established. But if one of them decides that they want to go out and hang their shingle and start taking on cases on their own, they can do that. Just like nurse practitioners can in the medical field. They may be solo practitioners, but they have to remain within the area in which they are certified, and that they should be treated, again, in the same manner as an attorney. Next. Also, and we talked about this, just Simmer and I were mentioning that there's something of benefit for lawyers currently in practice. You can partner with a legal paraprofessional and expand your practice. You can offer folks who are working with you. Let's remember, some paralegals or other office personnel have been with law firms for many, many years, and they understand the areas in which they have worked with attorneys for so long. It could be an incentive to promote certification among those who are experienced or who have shown that they have the talent that they could do this type of work. It's something that you can offer them as a step up. They may not be willing to, change their lives around and go to law school for 3 years, but certainly this is something they could do. Or you could hire legal paraprofessionals already licensed to assist and grow your practice. Or, because we have a whole other section that we're not talking about today, the alternative business structures, you could even partner with a legal paraprofessional. Also, whether you're hiring or partnering, you may offer unbundled services through legal paraprofessionals, or as we mentioned before, legal representation in those areas where lawyers are currently not practicing, and serve in Arizona's legal deserts. And this is a point that's really important, especially to me. We've seen, maybe not so much in Maricopa County and in the larger cities, but there are areas in Arizona where it's not only the fact that people cannot afford to hire lawyers, is that there are not enough lawyers to hire. And so a practice in Maricopa County, for example, could open a satellite office in Yuma or Northern Arizona, Apache County, and have people from that same community certified as legal paraprofessionals serve the needs in those communities, and then have that connection to the attorney office in Maricopa County. Next slide. So we talked about these examples in criminal law, how an attorney may use a legal paraprofessional at initial appearances, and in family law, how an attorney may have legal paraprofessionals handling matters that are less lucrative and they otherwise would not serve. I think that's all of my slides. And a quick knowledge check. True or false, a person denied admission to the practice of law may obtain legal paraprofessional licensure. So you've been disbarred, you've misbehaved, and now you're just going to be an LP, and we're going to be right back in the courtroom anyway. No harm, no foul. What do we think? Or did I say disbarred, denied admission. They're different. A person denied admission. False is the correct answer. You must not have, one of the requirements when you're applying for the legal paraprofessional licensure is that you not be denied admission to practice law in Arizona or other state. And that's
yeah, thanks, Judge Cruz. I don't know if you see the results, but our astute audience overwhelmingly agreed with you on that one.
And that's my presentation, just to recap.
Great. Thank you. Thanks very much. We have a couple other poll questions, and then we'll turn it over to questions. An LP may represent a party in their family law appeal, in that party's family law appeal. Okay, so overwhelmingly got it false. It meant to be false because appeals are one of the areas in family law, in addition to quadro, that are explicitly not included or excluded from the authorized scope of services. I'm sure those few of you who answered true have a very credible reason why, like maybe, they could work with a lawyer on it or whatnot, whatever it is, but it's designed to be false. Let's move on to the next one. An LP is subject to state bar discipline, true or false? All right, we're unanimous, absolutely. Of course, no early indication that they would be subject to more discipline or anything along those lines, but as many of you are working, in the legal community, if you do see something, of course, you are free to, and for substantial violations, you must report to the state bar. So if you do see anything awry, please do report. Thanks very much. And I believe this is our last knowledge check. So true or false, I may form a partnership with an LP. You don't have to, but you may. What do we got here? All right, we'll close it. So yeah, most of you thought that was true. It is true. The only sort of, or I guess significant catch, as I understand it, is that if it were to be a partnership, so an LP working in a law firm is quite already it's a normal practice, but to actually be a partner, so both directors or whatnot of the or partners of the firm, the ABS, alternative business structure application, would presumably need to be completed. I'm looking at you, Justice Timmer, to see if I got that wrong or not.
No, you are correct that to share the fees, you have to be an ABS, which is a separate licensing and errands division there to do that. That's actually one of the things that I think when we look at round 2 for refining some of these rules and what works, what doesn't, that might be one that we take a look at, thinking, is there really a need to be an ABS just if you want to give maybe your LP, a partnership interest. So, but for right now, you have to go through the whole ABS process to do that.
Thanks very much. Yeah, that's great. That was my reading. Although I agree with you on the next step. I mean, it just seems like lawyers and legal professionals are so much in harmony. The regulation is the same, that they could join together, without maybe the lengthy application process someday, but someday, not now. So thanks very much. We also put a link in the materials to Arizona Code of Judicial Administration 7-210, which is really the key regulatory provisions governing legal paraprofessionals. So for many of you who are thinking about becoming legal paraprofessionals, knowing those regulations and as they're amended from time to time is really key, not only to the exam, but to ethically and effectively practicing as a legal paraprofessional. So that, thank you so much to the panelists in the audience. And now we have a series of questions, many of which are focused on exams. And I just want to jump right into them. One, and Aaron, I'll probably lead on you, who in turn knows someone really wise named Suzanne as well. Is the LP exam like the bar exam?
It is like the bar exam in the sense that it's high stakes for your professional licensure. It is not like the bar exam in the sense that it's not 2 full days with essays and multiple choice. So it's an abbreviated version of that, but it is designed to test subject matter knowledge. So right now the pass rate is quite low, and there's maybe different reasons for that. Some of that you don't apply until after you've passed the exam. So we don't know necessarily if somebody's an experienced paralegal or somebody who just came across the website and said, yeah, I'll sit for that test and see what happens. So yeah, it should be taken seriously and studied for and prepared for and like that. But yeah, there are similarities and differences.
Thank you. And that actually answers another one of the questions. Let me first ask what I think is a simple one. Will there be a study guide available for the exam?
Yes, there is a study guide on the website. So azcourts.gov/CLD will take you to the Certification and Licensing Division's website, and then you can find legal paraprofessionals from there. And it has those historical exam results. It has the study guide. It has a link to that Code of Judicial Administration that applies.
Great. Yeah. Thanks very much. I see. I think I can paste that in to folks right now. There's a section for exams, and as Aaron Dooley knows, there's a brief study guide. It even has a couple of example questions. Maybe in time it'll grow. They're both on evidence, if I remember correctly. One thing that a couple people asked is, what about the exam? What sort of explains the exam passage rate, which is not great to date? I know the court recently released statistics, and it certainly got a lot better for repeat takers. But any other ideas on that? A couple of folks were wondering about why the relatively low passage rate so far.
Yeah, so partly there's the design process first of the exam. So ergometricians who go through and validate questions to make sure they test substantive knowledge without some sort of bias that works against the test takers, those kind of things. And the people who design the exam said, really, you got to get at least 100 people through the exam, maybe 200, before those percentages start leveling out. So knowing the audience would help. Who's taking the exam? Were they qualified in the first place when they took the exam? And then you can start looking at, okay, if there's a certain question a lot of people miss, maybe the question isn't worded right. So we're still early enough in the program with the numbers who've gone through it that we don't have all the answers to if it's questions or the applicants or something else.
Thank you. And we got a couple of questions relating to the time to license. So one phrased it as from the moment that I pass the exam to attaining a license, how many months that is. Another phrased it as sort of, including taking the exam. But can you give any thoughts about sort of a rough time frame if it's not too early to tell?
Well, there's a few different factors with that. The application process itself is there's a background check, a character and fitness check, like there would be for an attorney. So that can be extensive. And in that part, everybody's application is going to be different. It would depend on any sort of personal background that we would have to go through, people we'd have to interview about your background, those kind of things. There's also a background check. So the Department of Public Safety fingerprint checks can take a long time. Another piece of that is the regulatory board meets every other month. So depending on where you fall on that, could make a difference with the timing. But really, it's hard to give a specific time frame because everybody's background is different. If you've been a paralegal for 30 years and never been in trouble, that's going to go a lot quicker than somebody who maybe has to document everything back to their 18th birthday, or somebody who had was a defendant in the legal proceedings, those kind of things.
Thank you. We also had a couple of questions relating to the criminal law practice area, and wondering if Judge Cruz or Justice Timmer might have thoughts on this. The first, I'll ask them both. The first is, where do you see the LP program being most impactful or most used in the criminal justice system? And do you foresee DA offices hiring LPs in the future?
Well, I know. Just Judge Cruz, go ahead. You weigh in first.
Great question. Thank you so much. Actually, we didn't anticipate that prosecutors would engage legal paraprofessionals. As you know, currently for criminal law, legal paraprofessionals may practice in cases where there's no jail time at stake, either by statute or because it's been determined from the inception of the case that there is no jail pursued. So folks don't have the right to an attorney in those cases, and LPs may practice. But we did have inquiry from a smaller city within Yuma County, where one of the prosecutor's office does intend to hire an LP to represent the state in those same cases where they're not seeking jail time. And we looked at the rules, and we can't really find anything that says that can't be done. So that's an innovative way that the rule or the certification program will be used. Mm-hmm. And what was the other question? There was the prosecutors.
Where it will most be used, which I think you actually already gave the answer I would do, and that's in the bail hearings, because bail, whether you should be released or not, that's a huge issue, and it's a very confusing one, and people aren't thinking that. You're right. The family members are there or not, and you're just saying, I did it, I didn't do it, whatever, but no one's really focusing on what the judge really wants to know. So if you had someone there who can represent you, then I think that would be of immense help. It's still not clear in my mind how those people are going to know to be there, how we're going to bridge that. I mean, there's no office in the courts, not like public defender or anything like that. Although nothing would prevent the public defenders from hiring folks to be doing just that. But we're not quite that far along the road yet to see how this is going to develop. But that's where I see it going.
One other area is in representation of victims. I'm a member of the Commission on Victims in the Courts, and that commission is looking to request that the rule be changed to allow LPs to represent victims at any stage of a criminal case. Obviously, the victim's freedom is not at stake, and many victims, most victims, do not come to court with an attorney. So that's an area we will be requesting that it be expanded, even in felonies.
Thank you both so much. We had a couple of questions on the experiential. Actually, one potentially easy one first. A cluster of questions were, what can an LP do that a paralegal cannot do, or that sort of comparing either paralegals to LPs and lawyers to LPs. Would anyone like to comment on the differences?
Well, they certainly can't go to court. Paralegals can't go in court and represent someone. Technically not supposed to give legal advice, although I'm sure that goes on. But they're not technically supposed to be giving legal advice. Also, paralegals are to work under the supervision of the lawyer, and a legal paraprofessional does not have to. So I guess off the top of my head, those are three things that I can think of.
I think the easiest way to think about it is, as long as the LP is staying in their area of practice, they can do everything a lawyer can do, except appeal the case at the end. But as long as they're staying in their lane, they can do everything.
Thank you. Perfect. So a couple of questions asked about the experiential requirements. So, for example, in the Bachelor of Arts in Law or the MLS, you have to do an internship or externship or clinical opportunity that's in your contemplated area of practice, whether that's family, civil, criminal, or eventually administrative. So you do get experiential work that way. Linus Kafka and Christy Claremont can help situate you if you're in our program, and I know other programs have other outlets. So yeah, you do get experiential education by design in the program, so that you're ready to hit the ground running, so to speak. No one ever feels completely comfortable when they start a practice, but trying to get you in as good a position as possible. We had a lot of other questions. Program specific, Christy Claremont and UA, we have info sessions for future LPs very regularly. One's coming up in a week or two. please join that. We'll answer all program specific questions that might be of interest to you. Christine Husky, who directs our criminal law programs, asked a good question about how do we refer people to LPs? And that's possible now because we're starting to have this growing roster of LPs. You can actually look them up on the bar's website, but you could also talk with, for example, Christy Claremont, or Aaron's division has great resources on the web so that we can refer you to, if you have someone who needs an LP, we can refer you to them as appropriate. And we got a host of other questions, but time is not on our side right now. But what is on our side is these fantastic panelists who joined us today. Thanks so much for educating us all about the Legal Paraprofessional Program. And thank you to the audience for joining us. We're looking forward to continuing the conversation with you about this exciting new development into the future. Thanks so much.